So not much on what next by the court leadership, but lawyers commenting on the standoff between court and the Electoral Commission over the referendum signatures have revealed that the law is actually quiet on what exactly court can do about the issue. But they say court still has several avenues open if the opposition coalition decides to pursue the matter, and court is promising a showdown. KTN's Thairu has been on that story for us.
In July 2014, members of the opposition coalition led by their principals Raila Odinga, Kalonzo Musyoka and Moses Wetangula congregated at Uhuru Park grounds to officially launch the Okoa Kenya referendum drive. The aim being to push for crucial amendments to the constitution through a popular initiative, especially after their rivals in Jubilee declined to grant them the request for talks. 1.5 years down the line, and the much publicized initiative now seems to be a piped dream for the coalition after the IEBC announced that the initiative had not reached the requisite 1 million signatures. But now, what next for the coalition?
One of the things we were considering as an option is to go for verification, all of us, with the IEBC.
Another option that the opposition has is moving to the corridors of justice and seek for an interpretation of the law. And Article 257, the law is not clear on the next course of action that those pushing for a referendum through a popular initiative can take after the IEBC declares the initiative to have flopped.
The IEBC is a creature of the Constitution. It has made a decision that court feels is aggrieved. Therefore, the High Court has jurisdiction to hear that matter.
Court can actually go back to the court, can ask judges to interpret the law, and can confirm to the court that we do not have express law telling us that we cannot go back to the people, or that 891 being less, we cannot use it.
But the opposition leaders seem not so comfortable with the option of moving to court on grounds that they have no faith in the judiciary.
You may not trust a section of the court for some reasons, either experientially or because you have been hurt or because something has happened that you thought was not right. But at the end of the day, the court has an opportunity this time around to retest the judiciary of Kenya.
Given that the Constitution gives Kenyans the right to picket and hold demonstrations, court still has this option where they can use to whip up emotions of Kenyans as the demand for a fresh reconstitution of the IEBC.
The sovereignty of the people, as found in Article 1 of the Constitution, gives the people the supremacy over everybody else. The people delegate those powers to organs of the state, but the organs of the state are bound by the Constitution.
They can come back to the people, and when they explain that, depending on how they emotionally charge us, we may make our own decision.
And with the country lacking a referendum law that can set the procedures of conducting a referendum in the country, moving to Parliament and amending the Constitution to include the referendum laws still remains an option.
The court coalition might take power in 2017, so they will want no referendum law because they will want a status quo. The Jubilee are saying we are in power, we will retain the power. Let us not disturb the status quo.
Another option that the opposition court coalition has on the table is to go back to Kenyans and start the whole process afresh by collecting 1 million signatures before presenting them to the IEBC for verification. In the meantime, the opposition has organized a series of rallies starting this Thursday, where they will be in Malindi to try and convince Kenyans where they have no faith with the current IEBC as constituted. Thairu, KTN News.